Chad Biggerstaff here, an attorney here with Ramos Law, with another episode of The House of Law. Today we're going to talk about real estate, but more specifically the eviction process, which is actually called forcible entry and detainer action. Who knew? Stay tuned. All right, so we're going to talk a little bit about the eviction process. Now keep in mind, I'm not your attorney, and this should not be construed as legal advice, and you should always consult an attorney before taking any legal action. Okay, now that that's taken care of, calling all landlords and property managers. So you have issues with the tenant, you need to get them out. What do? Tenants have rights provided to them under the lease. You must legally remove those rights to regain possession of your property, and do so in compliance with Colorado Revised Statutes, rules of civil procedure, and of course your lease agreement as well. One note, if the property is a Section 8 housing or mobile home, there are separate, additional, and very specific rules apply to those types of properties, so look it up. Okay, you own or manage a residential dwelling, it's occupied by a tenant, under a lease, and the tenant has violated that lease in some manner. First thing you have to do as a landlord is you must post a notice of violation on the door. Now there are several different notices for a variety of violations, but all of them require at least that you describe the property, the violation, and provide a cure period to the tenant. Get this right, because if you get it wrong, you may have to start over. The notice must be posted on the dwelling in a conspicuous place that will ensure it's seen by the tenant. Front door, for example, bedroom door if you're only evicting one individual within a property, maybe the back gate if they park in the alley, something like that. Just be sure that they can see it. Now that the notice was filled out correctly, posted correctly, and no cure by the tenant has occurred, the landlord must prepare a summons and complaint. There are specific rules governing these documents, so do it right, because if you don't, you may have to start over. Once the summons and complaint are complete, those two documents, along with an answer form that the tenant has the right to respond to with, must be served on the property. You do not need to personally serve the tenant with these documents, as is the case with most civil actions. You've probably seen on TV somebody bumping into somebody, asking them their name, handing them a bunch of documents and saying, "You've been served." That's not needed here, at least not for this possession part. The reason is a forcible entry and detainer action is an in rem action, which translates to of the thing. No personal service is required. You only need to serve the thing, the dwelling. So you post the summons and complaint in a conspicuous place after attempting to make contact with the tenant, which is not required for the notice we talked about a second ago. But it basically means you knock on the door. If the tenant answers, you give it to them. If they don't, you post it on the door and you attempted to contact them. Now, one very important thing I haven't mentioned about serving these documents is they must be served by a disinterested third party. You can't serve them yourselves. So get a process server to have the documents served. Always check your service requirements before you do anything, because if you serve it incorrectly, your case may be dismissed and you have to start over. You must also file the summons and complaint with the court in the county of the property resides in. And included with the summons and complaint, you must include the notice of opportunity to cure, which is the notice you posted on the door, the lease, providing the provision that was violated by the tenant that you stated in the notice you posted on the door, and the certificate of service from the disinterested third party who served the summons and complaint on the property. Always check your filing requirements. Again, if done incorrectly, your case may be dismissed and you may have to start over. Now that that's all done, just make sure you show up at the hearing on the date and time listed on the summons and complaint that was served on the property. If you don't show up, your case will get dismissed and you'll have to start over. At the hearing, a couple different things might happen. Now, if the tenant shows up, you can enter into an agreement with the tenant, whatever you guys agree to. I'll give you a week to move out. I'll give you 2 weeks to move out. You pay me this much and I'll give you this much time. Whatever you guys come up with, put it on a piece of paper, give it to the judge. Judge makes it an order of the court. You follow that order, everything turns out good. The tenant can also show up and file an answer to your complaint because they want to fight with you. If they file an answer, a trial will be scheduled for 1 week later. At this trial, you will have to prove that you had the right under the lease to evict the tenant and you complied with all the requirements that govern this type of an action. Now, if the tenant doesn't show up at the hearing, you can just simply request a default judgment for possession of the property. Once the judgment for possession is entered, either by default because the tenant didn't show up at the hearing, or by being successful at proving your case at trial, you may then request the judge to issue the writ of restitution. That's the court order that you will take to the sheriff's office to have them execute on. Now, execution on the writ of restitution is when the sheriff goes to the property, removes the tenant from the property, and you clear out all their belongings as directed by the deputy. Yes, I said you clear out all the belongings in the property. So have some people with you and be ready to do it. The sheriffs usually like it to be done in about an hour. That's it. Change the locks, move on. Look for a new tenant. Hope you have better luck next time. That's it for today. Be sure to join us next time for another episode of the House of Law.